Hi, my name is Randy and I'm a law student at the University of Pennsylvania. In this video, I want to give you some important historical and statutory context that might help you understand the complicated and sprawling significance of Heart of Atlanta Motel as you and your teams formulate and analyze the arguments being presented by the parties. The first thing you might notice that is pretty counterintuitive is that there's an awful lot of discussion about the Commerce Clause for a case involving discriminatory motel accommodations. To understand why, it's necessary to look at some really important events in U.S. history. After the Civil War, in a period known as Reconstruction, Congress attempted to institute expansive civil rights measures to protect black people. They passed the Reconstruction Amendments. The 13th abolished slavery and involuntary servitude, the 14th guaranteed equal protection of the laws, and the 15th extended voting rights to black men. Congress also passed the Civil Rights Act of 1875 in order to enforce the 14th Amendment and stop civil rights violations against black people. The act entitled everyone access to accommodation, public transport, and theaters regardless of race or color, similar to the public accommodation provision of the 1964 Civil Rights Act being debated in Heart of Atlanta Motel. But the Supreme Court struck down the public accommodation provisions of the 1875 Act. In the civil rights cases, where 5 black Americans sued a variety of whites-only facilities, the court said that the 14th Amendment's Equal Protection Clause was only designed to prohibit discrimination by the government, not by private individuals or corporations. It would take almost a century before Congress would try again, and this time, instead of hanging its hat on the hook of the 14th Amendment's Equal Protection Clause, Congress would argue its authority under its Section 1 Commerce Clause powers enumerated in the Constitution. Let's take a look at it. The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. This power to regulate commerce between the several states is referred to as the Interstate Commerce Clause, and it is one of the most argued over concepts in all of constitutional law. This is because, depending on how you interpret it, the clause may or may not give the federal government expansive power. Early Supreme Court cases were quite deferential to Congress, liberally interpreting what qualifies as commerce and what qualifies as interstate. But by the turn of the 20th century, the court became much more protective of private contract rights, or what you might call economic liberty. We call this the Lochner Era. The court struck down minimum wage laws, banking regulations, railroad regulations, and even federal attempts at curtailing child labor. The court argued that economic freedom was such a fundamental right that it permitted no infringement by the government, no matter how compelling the reason. In the 1930s, when the Great Depression crippled the global economy and President Roosevelt attempted to pass a number of economic measures as part of his New Deal legislation, the Supreme Court initially invalidated large portions of Roosevelt's legislative efforts as unconstitutional exercises of the Commerce Clause. But in 1937, for reasons that historians argue about, the court began to side with the government's argument that national economic problems require national solutions, and that the Commerce Clause gives them that power. In West Coast Hotel v. Parrish, the court upheld minimum wage law and said that the liberty to contract can be restricted in the interest of protecting the community, regulating health and safety, or protecting vulnerable groups. In U.S. v. Darby Lumber, the court upheld congressional regulation of labor conditions, and in Wickard v. Filburn, the court upheld congressional limits on purely local wheat production and consumption by a single farmer, arguing that the collective impact by a group of farmers to grow over the quota could have a negative impact on interstate commerce. Which brings me to the case before us today. Can you see why the Congress that passed the Civil Rights Act of 1964 chose to argue its authority to do so under the Commerce Clause and not simply the 14th Amendment promise of equal protection of the laws? Should the Commerce Clause extend to civil rights legislation?